All right. Good morning, everyone. I'm Whitney Diver McAvoy. I am the president and CEO of the Yountville Chamber of Commerce. And thank you so much for joining us here today for our employment law update with Jennifer Douglas, partner at Dickenson, Peatman Fogarty. There are a lot of new laws that have come across the state of California this year. So we are very grateful that Jennifer has taken the time to do this with us today. So feel free to ask questions throughout this presentation. Jen and I talked about that a little bit before we got started here. If something comes to mind, go ahead and raise your hand, or you could unmute yourself as well, or type it into the chat, and I'll go ahead and alert Jennifer to anyone that has a question. So we'll also have a few minutes at the end for questions as well. All right, Jennifer, I'll go ahead and turn it over to you. Thank you so much for being here with us today.
You're welcome. Thank you, Whitney, for inviting me. It's always exciting to come to Yountville's Chamber of Commerce webinars, and maybe eventually we'll actually be in person, but it's nice and convenient for all of us to be able to do this from our desk. So I'm excited to be here and look forward to working with you guys through these updates this morning. So we'll go ahead and get started. We've got a lot to cover, as Whitney mentioned. And if you have questions, as she said, just my preference is to make this a little more interactive. So please, if you have a question, either put it in the chat or raise your hand. Whitney's going to be monitoring that, and she'll interrupt me and say, hey, there's a question, and we'll deal with it at that point. If you have something that you think is more specific to maybe your situation versus something that would be applicable to the whole group, if you wouldn't mind holding that to the end, and we can either deal with that at the end, or you can contact me separately. All right, without further introduction, we'll get started. So I just, I'm a lawyer, so we have disclaimers. So we're going to start off first with just a disclaimer that although I will take questions throughout this webinar, the session isn't intended to be, it's intended to be general information. So it's not intended to be legal advice for any specific situation. And I might try to be funny. I don't claim to be funny, but to the extent that any humor is used or attempted in this presentation, it is not intended to offend anyone or indicate that I take any of the topics lightly. All right, I always like to start my updates with reminders because, as California always has new employment laws, we still have to comply with all the other laws that were in place before. So it's always a good idea to make sure that we're keeping those in mind, because those are things that continually crop up in our day-to-day working environment in the employment law section. So the first and foremost should be on the top of your mind every single day, whenever you hire someone, whenever you're doing payroll, is to make sure you're paying minimum wage, right? That is very critical. So in California, this was increased to $15.50 an hour as of January 1st, and it's for all employers. There's no longer any delineation between a smaller employer or a larger employer. It is $15.50. There are local ordinances that have different rates, higher rates. So for example, Santa Rosa, the minimum wage is $17.06 for everyone. San Francisco, oddly enough, is only $16.99, but that will be adjusted in July, which I'm sure will go up at that point. Yountville doesn't have its own ordinance. So if your employees are only in Yountville, then you just need to apply the state minimum wage. But if you have any employees that work 2 hours or more in any other municipality, you need to be checking those municipalities to make sure that you're paying at least minimum wage in those areas. Along with minimum wage, this is where we see the most problem, because most people are paying, above minimum wage in order to attract workers, right? There's probably no one here on this webinar that's paying minimum wage for their employees, but the salaried exemption is really where we see the most difficulties. So just as a reminder, so in order to have someone be paid by salary in California, you need to be paying them at least twice the California state minimum wage for full-time employment. Full-time employment is considered under the state law as 2,080 hours, which is 40 hours a week for 52 weeks a year. That doesn't mean, this is just a caveat, but that doesn't mean you have to classify that as a full-time employee, meaning that a lot of people classify full-time employment as 32 hours a week or 35 hours a week for their own benefit purposes. This is just for salary purpose. So under California law, it's 2 times the state minimum wage For full-time employment, which is considered 2,080 hours, if you do the calculation, that means for this year, 2023, you have to be paying a minimum of $64,480. You cannot have any salaried employees making less than that. It's a big jump. If you're a small employer, this is a big jump. You've gone from $58,240 to $64,480. It's a $6,240 raise. So you need to make sure that you're complying with this, because if you don't pay this amount of money, doesn't matter if it's your CEO, that person needs to be paid by the hour. They'll be considered a non-exempt employee. And if they work overtime, you owe them overtime. So really important to make sure you're paying your salaried employees properly. And along with the salary, we're not getting into that in this particular webinar, is to make sure that the duties qualify as an exempt employee. We get a lot of times there's borderline, your first line supervisors. There's always some question about whether they really are salaried or not, or a lead, for example, maybe they're not in charge of the whole department, but they're in charge of a few people. Those are always really close calls. So just be careful. You can always pay someone by the hour. If you choose to pay them by the salary, as an exempt employee, you have to really make sure it's done right, because it can be very expensive if you don't. Looks like there's a couple of questions in the chat. Whitney, are they?
Yeah, there is first question was from Jennifer. She asked, salary California minimum wage, does this include regularly scheduled commissions?
So I'm not exactly sure I understand the question, but I'll answer it. I'll answer two parts of that. If you pay anyone by commission, you can pay commissions. You can have someone who is an outside salesperson, for example. So if someone is and a lot of the wineries have salespeople across the country, right? And they're out calling on customers, restaurants, distributors, and they are considered an outside salesperson. You can pay that. They are not subject to minimum wage at all. You can pay them 100% commission, and they could get zero until they make a commission. So but that's a very discrete classification of a commissioned employee. Commissions, I think what you may be asking is, commissions do not count towards the salary. So you can classify it. I mean, I guess it maybe depends. Like you're saying that you have a guaranteed commission, it really needs to be the salary. So if in order to get this $64,480, you're saying that a part of that is commissions, it's going to be okay if it gives it to them every time, unless you have a provision you can claw it back. If the commissions are really a draw or an advance that can be taken away from someone, then it's not going to comply. It really has to be a set payment that you're giving someone every single pay period. Does that answer your question? Yeah,
that's a great question. And I'll just say, perhaps Jennifer could follow up with you directly if she needs more clarification on that. And then the next question here is, do you have to pay the minimum wage if the person lives in Santa Rosa, but they work in Yountville?
Good question. No, the minimum wage goes to where they're working. So the opposite's true. If someone lives in Yountville, but they work in Santa Rosa, you got to pay them the Santa Rosa rate. So it's wherever they're working. So I'll go back up to that slide. So if you have employees, they have to work at least 2 hours or more a week in these municipalities. So it would apply if you had someone who was working part of the week in Santa Rosa and part of the week in Yountville, right? Then you would have a problem if they were working remote from home in Santa Rosa. Yeah, so you gotta be, you just have to be careful about that. So, but if they're working, it goes from where they're working. So if they're working in Yountville, it doesn't matter where they live. They get paid Yountville wages. Okay. Moving on. So the second reminder I wanted to make for people is to change in overtime. All of this is evolving. So those with 26 or more employees, we're fully committed to the 8 hours, overtime over 8 hours in a day, 40 hours in a week. For the smaller employers with 25 or fewer, it has started its phase in. It is this year, 2023, it's overtime after 9 hours and 50 hours in a week. 9 hours in a day, 50 hours in a week. Remote work policies. This is really just a reminder. If you have employees that work remote, you really should have an agreement. If you don't have any written policies or an agreement, and this happens for many of our clients, because this happened, especially with COVID, things just kind of evolved quickly, and all of a sudden you had all these remote workers, right? And you didn't really have set policies. It was sort of temporary, and then it turned into much of a longer stint, and some people are still remote. You really should pause now and make sure you have something in writing that governs your employees that are working remote. So here's some on here. There's some ideas or areas that should be included in whatever that policy or agreement is. You should protect your own proprietary customer company information. There should be an expectation that the employee will maintain their home and workspace in a safe manner, because workers' compensation covers employees no matter where they're working. So if they're working from home, you're still responsible if they get injured while they're working. Requirement for hourly employees to maintain accurate time records and document meal breaks. We saw a lot of issues with that. I don't know if any of you have hourly employees that are working remotely, but if you do, you probably are conscious, maybe directly or maybe in the back of your mind, like, I don't know, are they really tracking their time accurately? And you're responsible for it. So you should make sure that there's some policies governing that and that someone's checking on it. And you need to have an ability to revise. So you need to have the ability to say, hey, you know what, we're going to have you come back into the office, or, we need to change the way we're doing this. Reimbursement, that's another key area. Again, remote work came up pretty quickly. And so our policies are sort of catching up to the reality of people's working environment. So if the reimbursement is broken out into two different categories of people, of workers. So if someone is working remote because the company has decided that that's this position, meaning that this position is 100% remote, it's mandated by the company, then you are responsible for all of the expenses related to that remote work, cell phone, home office expenses, that sort of thing. If it's, hey, the employee says, I would like to work remote, and you choose to allow them to work remote, even though you have an office space for them dedicated in your building or your workspace, then that's a voluntary remote work, and you're not responsible for paying those expenses. So those two things are really important to keep in mind. I just tagged on here at the end, just a reminder that the IRS mileage rate went up effective January 1st, 2023 to 65.5 cents. So make sure that was a pretty big jump. So just make sure you've got that noted. Number 4, this is just a reminder, you need to keep doing your harassment abusive conduct training. It needs to be done every 2 years. It's 1 hour for your regular employees, 2 hours for your supervisory employees. This is if you have 5 or more employees. New employees or someone who has just become a supervisor, so a new supervisor, you have to complete this training within 6 months of them being hired or promoted into the position. You can't just keep them on the 2-year cycle. There's also rules for seasonal employees and temporary employees. If you have seasonal employees or employees that you hire temporarily for a particular type of season or event, you need to train them within 30 days. So you can do online training. That seems to be the easiest, especially if you have a lot of people that come and go in your organization. The California Civil Rights Department, which was formerly the Department of Fair Employment and Housing, has free online training. And I've included a link here that you can go and sign up for that if you want. I will say a shout out to in-person training. If you tend to do one training every 2 years for all of your employees, it's really nice to do it in person. If you can, it's more effective. You can use your own policies. It allows people to ask questions. It's definitely a much more effective training at getting at the root of any potential problems you might have at your location or your facility. But the online training is a very simple way to make sure you at least get what you need to have done in compliance with the law. Number 5, CalSavers. I'm not going to spend much time on this. You just need to remember that if you have 5 or more employees, you need to be involved in CalSavers. Make sure you have some kind of retirement or some kind of retirement plan in place. If you have 1 to 4 employees, you're going to need to comply by December 31st, 2025, but you can start as early as this year to get it going. And 6, arbitration agreement. We're going to hear about arbitration agreements a lot. It's one of my mantras for my clients. Hopefully none of you have been involved in litigation, but if you have, you understand the pain that employers can feel by feeling like you're powerless. There is not a lot of tools that you have in fighting litigation as an employer in California. For right or wrong, mostly right. Employees need a lot of safeguards to help them navigate some of the issues and be able to address complaints. But the law is not employer friendly. So having the ability to have an arbitration agreement, particularly with class actions or representative actions, is really helpful for your business. So back a few years ago, you all may have heard of AB 51. That was a law that was put into place in 2019 that was going to apply as of January 1st, 2020, which was when it prohibited mandatory arbitrations. It put a complete hold on mandatory arbitrations for arbitration agreements that were entered into after January 1st, 2021 or 2020. This law was immediately challenged by the Chamber of Commerce, California Chamber of Commerce, and it's finally worked up to a resolution at the Ninth Circuit Court of Appeals yesterday. So you are getting groundbreaking news. The court finally, and it only took 3 years to get there, the court finally ruled that it is preempted by the Federal Arbitration Act, which means that the Federal Arbitration Act, which is in favor of enforcing arbitration agreements, is going to control and preempts California's law, which means that employers can have mandatory arbitration agreements in place with their employees, meaning it's a condition of employment, that they don't have a choice. It's not voluntary. It doesn't mean you have to have an arbitration agreement, but it allows you to do one if you want to have it in place. You still should monitor case developments, and we'll see why as we get down a little bit further in the hour. I'm going to talk a bit more about it. And you should analyze whether mandatory arbitration agreements are right for your business. Privacy rights. This could have its own webinar. I'm going to just go skip over this so we can get to the other stuff and just remind you that if you fall into the categories where this would apply, you should really talk to counsel to make sure that you're complying with your privacy notice obligations. And whether it applies to you is right here on this slide. So it only applies to for-profit businesses that either derive at least 50% of their annual revenue from selling or sharing personal information of California consumers, or have a gross revenue over 25 million, or buy, sell, or share the personal information of more than 100,000 California consumers or households. Probably most of you are not going to, you're probably not in the business of selling the data of your employees. If you are subject to this law, it'll be because your business has revenues of 25 or more million. So anyway, keep that in mind. If you do fall into that category, I would consult with your legal counsel to figure out if you've got the compliance right. And I will send this presentation to those that want it, and you can read a little bit more about it here, and there's a link for more information. All right, notable cases for this year that are going to play into your practice and your business. These two cases dealt with off-the-clock work. So Cadena versus Customer Connects was a Ninth Circuit Court of Appeals case that came down in October. Oddly, both of these cases came down on the same day from different courts. But in Cadena, the court found that turning on and booting up computers at call centers was integral and indispensable to the worker's duties, considered a principal activity that must be compensated. What does that mean? So the case involved call center employees that would get to their office, walk to their workstation, turn on their computer, wait for it to get up before they could actually clock in, right? There's probably a lot of us that have to deal with that, right? You have computers that you clock into. Maybe it's a time clock that is farther away and there's a line of people that you have to go through before you can clock in. This is all saying that all of that wait time before you have to clock in is potentially compensable. You'll have to figure out a way to compensate people for that. And the key to that was whether it was indispensable to the worker's duties. So in this case, using the computer, they needed to access the computer before they could start working. And so they had to wait for it to warm up before they could clock in and then use it for their job. The court in Camp, that's the next case, Camp versus Home Depot, found that although Home Depot's rounding time, this has to do with rounding. I don't know if any of you are still using a rounding for your time purposes, timekeeping purposes, but this case should cure you of that. The court in Camp versus Home Depot found that although Home Depot's rounding time keeping practice was neutral, meaning that if you looked at it over the span of a year, that the time, in rounding, just to back up, rounding is when, like, say, you clock in at 9:55, it's going to round you up to 10. If you clock in at 9:52, it's going to round you down to 9:50, or sometimes it's a 15-minute, sometimes it's a 10-minute rounding. So it's rounding up or down depending on where you fall in the actual clocking in of the time. And you look at, in years past, how this has been looked at is rounding is fine as long as it's neutral, meaning that over the course of a year, if it evens out, that when it's rounded up or down, it comes out to be even, then it's okay. So the court looked at this and said, even though the timekeeping practice was neutral, because it was possible for Home Depot to actually track the actual hours that the employees were clocking in and out, they should be tracking and paying for the time worked, which, is a little ahead, but so there's no point in time. So basically they're saying, there's no rounding available because the time clock is tracking it. So why would you round it? So the court's saying, because you can track it, you can't round it. This is a Court of Appeal case. It is not controlling for the state of California, but what the Court of Appeal did do is they certified questions to the California Supreme Court on this issue to determine when, if ever, rounding would be okay. So stay tuned for that. But the bottom line is the writing's on the wall, stop rounding. So if you're still rounding, go to straight time. It could be a little painful in the beginning from both the employee side and the employer side. The employer side, you're going to start having 1 to 5 minute minutes of overtime potentially on days during the week. And for employees, you might get paid less. They might get 5, 10, 2 to 5 minutes of time that they're not getting compensated for, that they used to be compensated for, because now they're going by exact time. All right, so the bottom line for both of these cases, what you can take away from this is that courts are really looking at compensating employees for every minute that you are controlling the employee's time. Any time that you can track, they expect you to pay them. So you need to really be looking at your timekeeping practices. A lot of my clients are moving to using a mobile app on their phone for people to clock in and out so that they can have more availability to clock in real time, as opposed to waiting to get to a particular place. The next set of cases are arbitration agreements. I won't spend too much time on this so that we can get going, but they're really important. And so I don't know how many, maybe we can do a survey. If you guys can raise your hands, how many people have arbitration agreements in place? I don't know if people are raising their hands. So only 2, 3, 4. Only 4 of you guys. Well, 4 that raised their hands. So there may, that's either you guys aren't raising your hands or that you don't have it. But I will tell you that it's really, as I said in the beginning, such a vital potential part of your risk management for your company. So something to really think about. And if you're not part of senior management for your company, I would urge you to take this, what I'm saying to you here, and maybe go to your senior managers and really talk about it, because it's timely, because of the case that came down yesterday that really frees up. There's been a lot of anxiety about enforcing arbitration agreements with the threat of what happens if that law does become law, and now these agreements are unenforceable that I've mandated my employees to sign. That's gone away. So you really should think about it. So these 2 cases are really important for PAGA, and I hope that none of you have had to deal with PAGA. PAGA is a private attorney general act. That's the name of the law. It is a little bit of a backdoor way for people to bring a class action. What a PAGA action is when an employee steps into the shoes of the labor commissioner and sues the employer for penalties, just civil penalties. It has nothing to do with wages that the employee thinks they're entitled to, nothing to do with whether they were wrongfully terminated. This employee could have stolen from you. They could have worked for you for 5 days and they left and they were just the worst person. Doesn't matter. They can step into the shoes of the labor commissioner. They can sue you for penalties on behalf of all of your hourly employees back for a year. And this law has created sort of a cottage industry, particularly in Los Angeles area, of lawyers bringing these, just casting about and bringing these cases. It's not to say that there are not some employers that are wholesale violating the labor code and should be held accountable, particularly by the labor commissioner. But that's not necessarily what this law is being used for. It's a moneymaker, make no mistake about it. And a number of cases that I've been involved in representing employers, I would say the majority, maybe 9 times out of 10 or even more, the majority of the time, the employee that's bringing the action believes it's being brought on behalf of their own concerns, not that it's being brought for these particular labor code violations. There's a lot of misunderstanding about what's being brought on in their name. So it's really become abused, I guess is the bottom line. So anyway, what had happened was, if you had an arbitration agreement, normally they have a class action waiver, which means you have an agreement. It says you cannot bring a class action against us. You can only bring your claims as an individual. And this was originally included PAGA actions. The California Supreme Court ruled a few years ago, you cannot force someone to bring a PAGA action in arbitration. It can only be in the courts. So the last few years, that has been made a dramatic increase in PAGA actions that we've seen from lawyers against our clients. The US Supreme Court ruled in June of this past year that an employee can be bound by their arbitration agreement from a representative waiver, meaning that there's a representative waiver in their arbitration agreement, they can be bound by it, meaning they have to litigate in arbitration their individual PAGA claims, and then they cannot bring a representative PAGA claim. That was huge. We've seen a decrease in filings of PAGA claims since then, which is fantastic. But under so this is right now is this law, this landscape that says that if they are forced to bring their PAGA claims into arbitration, that they lose standing to bring one in court. California courts are not giving up on this. Now remember, this is a US Supreme Court decision that just came down. Some California courts really want to allow employees to continue to bring this representative action in court, even if they have an arbitration agreement. So that part is not exactly settled. There's still so much value in having an arbitration agreement. I still encourage you to really bring it, or to enforce it, I should say. The second case is the Bonta case that I mentioned earlier, that basically stated that the AB 51 law is preempted and employers may impose arbitration agreements. California law does require you to have a carve out for sexual harassment, meaning that employees that feel that they've been harassed or discriminated or retaliated against based on sexual harassment or sexual discrimination, they have to be able to bring that, they have to have the option to bring it in court if they want to. So that's the only carve out that's still viable. All right, we're going to move on to the new laws passed in 2022. Whitney, do we need to take any questions before then?
Nope, I don't see any more in the chat. I'm not sure if anybody has any questions that they'd like to ask at this time.
Okay. All right.
Good.
All right. So the first law we're going to talk about is pay transparency. I'm sure if any of you are doing hiring, this has obviously been something that's been front and center for you. So the pay transparency law, SB 1162, it amends 1299 of government code section 1299 of the government code and section 432.3 of the labor code. What this requires is that all employers must provide a pay scale upon request for a position in which an employee is currently employed, and keep records of the job postings and wage rate history for hired employees for the duration of their employment plus 3 years. So it becomes really part of a personnel file, right? So you have to keep personnel files for the duration of employment plus 3 years. This is the same time frame. Actually, personnel files for 4 years. What's different about this is providing the pay scale upon request for which the employee is currently employed. This is the new part of the law. The old law said that applicants, people that you were interviewing, could ask for the pay range for the job that you were hiring for. Now employees can. So what you should be doing with this is make sure you have gone through all of your jobs and figured out the pay range for your jobs in the event your employees come and ask you, what is the pay scale for my job that I'm doing? The other part of the law deals with employers that have 15 or more employees. In this one, you must include the pay scale for positions in all job postings. So if you're posting a job, whether it be through a third party or directly through the Chamber of Commerce or through Indeed or any other search engine or on your website, you have to state what the pay range is for that job. And by pay scale, they mean the salary or hourly wage range that you reasonably expect to pay for the position. Now, what you reasonably expect to pay for the position, you've seen a lot of commentary probably from secondary sources about what does that mean. Some people, well, I'm just going to put, zero to, can't say zero because you have to pay someone. So they, put this huge range of like, $20 an hour to $50 an hour. And, you can do that if that's what the reasonable expectation of the job is. But you should really put some thought into what am I going to pay? What is this job worth? How much am I supposed to pay for this job? It is really a, reasonable expectation is sort of a squishy term, but it should be realistic, and for a variety of reasons. One, because the law says so, but two, because you want to attract the right candidate. And if your job, if it's too wide of a range, then you may be turning off job candidates that think that you're just trying to take advantage of the system. And if there really is such a wide range, then I would encourage you to break that down into tiers. So, a beginning level is $20 to $30 an hour, medium is, 30 to 35, and the top is 40 to 50 or something. There seems to be ways, if it's going to be based on experience, and you can break it down into tiers.
We have a question on this, Jennifer.
Sure.
Fabiana, and she asked, what if you don't have a range, for example, and you pay them minimum wage because they earn tips on top of that?
Sure, then you would just say minimum, and you would just put the minimum wage, whatever that is. You would say $15.50 plus tips. You don't even have to say plus tips, but it doesn't matter. The wage range, the wage that you would be paying is $15.50. It doesn't have to be a range if there isn't one. If there's an exact amount, you can put the exact amount. Good question. Okay, so under the pay transparency law, there's a possible civil penalty of $100 to $10,000 per violation. Obviously, that's a big range. It's going to depend on the culpability and the scope of the problem. But there's no penalty for the first offense as long as you update all job postings for the open positions and add the pay scale. They really want people, the point is that they really want people to comply with this. And private employers, with the other part of the pay transparency law is this reporting component. So if you have 100 or more employees, you're also required to submit a pay data report annually to the California Civil Rights Department, CRD, on the second Wednesday of every May for the preceding calendar year. So it's separate from your existing federal requirements under EEO-1. And the reporting can be completed on their portal. And I've included a link here to their portal. Okay, moving on. AB 1041 is the next new law that has to do with a designated person for CFRA and paid sick leave. This, a lot of our California laws that have been progressive have started from San Francisco's municipal laws, and this is one of those. They've had the ability to designate a person for paid sick leave for years, probably 10 years or more. This now has finally been passed in California statewide. Beginning January 1st, 2023, employees may use their protected family and medical leave under California Family Rights Act and their California paid sick leave to care for a designated person. There's two different definitions of designated persons, depending on the law. So, and hopefully they'll make them consistent, but they were passed at different times. And so this is how it's come. CFRA definition: designated person is any individual related by blood or whose association with employee is equivalent of a family relationship. And in the paid sick leave, it's added designated person to the definition of family member and can be anyone designated by the employee. So in PSL, you can have anyone designated. In CFRA, it has to be the equivalent of a family relationship. It's a small distinction, but there is a distinction there. Employers can limit employees' use of the leave to one designated person per year. So you know, if someone gets sick, your neighbor is sick, and you really want to, you're very close to that person, you want to take care of them, you can designate that person for your paid sick leave this year. Next year, you can designate your best friend. It depends on, you know, it doesn't have to be the same person. It must be designated at the time of leave. So each leave that you take, it has to be designated at that time. AB 1949 has to do with bereavement leave. This added section 12945.7 to the government code. This, beginning January 1st, 2023, employers with 5 or more employees are required to provide 5 days of unpaid protected leave for bereavement purposes upon the death of a family member. Applies to all employees who have worked for the employer for at least 30 days. So the only caveat is that they work for you for 30 days. They do not have to take the 5 days consecutively, but they must be completed within 3 months of death. The bereavement leave is available for each qualifying death. So if someone would be so unfortunate to have multiple family members die in a year, there's no limitation on the 5 days that are to be provided to them. The employer has the right to request documentation of the death of the family member, and employees can elect to use accrued vacation, sick time, or other paid time off for the leave if you don't have a paid leave. A lot of what we've run into is a lot of people have policies already in place that have certain amounts of, like, maybe 3 days of paid leave, and so you have to figure out how to integrate that with this. So since the requirement is it doesn't have to be paid, it's unpaid, the employee has to be able to use their accrued time off. Definition of family member under the statute is the same as CFRA. However, there's no designated person. It is the definition of all the family members under CFRA, which we don't have listed here, but that's going to be all of your family members, your immediate family members, grandparents, siblings, but it's not going to include the designated person that the actual CFRA leave allows. Any questions on that? AB 2188, so restrictions on cannabis discrimination. We stuck this in now. It's not actually in effect yet. It's not going to go into effect till January 1st, 2024. But there's been a lot of buzz about it, so it's good to just make sure it's on your radar. This deals with off-duty cannabis use. It will be protected. It's an actual protected class under the Fair Employment Housing Act. It will be as of January 1st. It prohibits any discrimination against an employee for off-duty cannabis use and a drug test that is positive for non-psychoactive cannabis metabolites. So what that means is if you do a drug test, you can't use a drug test that's going to screen out for cannabis use unless you can show that it's active, psychoactive cannabis metabolite. So it has to be active as opposed to non-active. So the non-psychoactive cannabis is the CBD, and the THC will stay in your system. THC is what is considered the psychoactive, but it stays in your system longer than when it is actually effective to you. And what's unfortunate about this, and probably why they are extending this until January 1st, 2024, is there is no readily available test that can test whether the THC is a psychoactive or non-psychoactive at this point. So hopefully there'll be some developments over the next year. Give them time to come up with that test. If there is no test, your probably best bet is just to not test for cannabis at all. Employers may still prohibit on-duty possession, impairment, or use. So you can still drug test to measure the presence of THC, but again, unless you can show that it's active at the time that you're testing, it would be difficult to prove that they were under the influence. But certainly the possession of it and the impairment is going to be the factor going forward. And it does not apply to employees in the building and construction trades, or those applying for positions that require a federal background check, or positions where state or federal controlled substance checks are required. So there are still some restrictions in certain jobs that will allow you to continue to test. SB 1044, no retaliation against employees in emergency situations. So this adds Chapter 11 to Part 3, Division 2 of the Labor Code, Section 1139. Employers are prohibited from taking or threatening to take an adverse action against any employee who refuses to report to work or leaves work due to their reasonable belief that workplace is unsafe or the existence of an emergency condition. So an emergency condition includes disasters like wildfires, orders to evacuate a workplace, an earthquake, criminal acts, anything that's sort of, it's a sudden thing, it's beyond the employer's control, it just happens. It does not, specifically in the statute, it does not include a health pandemic. So it was specifically written, this doesn't include COVID. It's considered looking at just really addressing the fallout from wildfires that we've experienced. It prohibits employers from preventing employees from accessing communication devices, so like their cell phone. So you can't have policies that say you can't use your cell phone at work without having an exclusion that allows them to use it in case of emergencies. Most people have that kind of policy. I haven't seen, when cell phones started to become, I'm old enough that, that I was practicing employment law before cell phones were so common everywhere. The first policies were very prohibitive, no personal phone calls, no use of your cell phone at work. And that has started, as our phones are attached to us, we wear them on our wristbands now, right? So it's difficult. You can't say that it's not going to be around or not be used, but you can put reasonable limitations on it. So as long as, if you have such a policy, and the only time where we really see that now is maybe on a production floor in the bottling, room, or something like that, where it would be a hazard to have your phone out, or a customer facing, like in a tasting room or in a, receptionist in an office, or, a hotel front desk person. You don't want them on their phone as someone walks up, right? You can prohibit that kind of use, but you would still need to have carve outs for emergency situations. All right, SB 523. This is the addition of reproductive health decision making as protected class. So this adds and amends multiple sections of government code, health and safety codes, insurance codes, and public contract codes. This came out of the Dobbs case, which basically overturned Roe versus Wade this summer. California passed this law to amend the Fair Employment and Housing Act to prohibit employment discrimination on the basis of an individual's reproductive health decision-making. So this is a new protected class. So if you have a handbook that lists all of the protected classes, you should add this as a protected class in your handbook. Reproductive health decision-making includes, but is not limited to, a decision to use or access a particular drug, device, product, or medical service for reproductive health. I can't imagine a situation where someone would be asking about someone's vasectomy or birth control or abortion in a workplace setting, but this basically states that you can't make any, you can't discriminate against any employee for any of those sort of decisions or steps that they may be taking towards their reproductive health. Employer cannot require, as a condition of employment or continued employment or a benefit of employment, the disclosure of information relating to an applicant's or employee's reproductive health decision-making. And it expands the required health plan coverage to include contraceptives starting January 1st, 2024. All right, before we move on to talking about COVID, which, eventually we'll get to stop talking about COVID, but we're going to talk about the updates as of 2023 for COVID. Is there any questions to the other laws that we just went over?
I think I was just going to ask, if somebody on this call needs help with their employee handbook or something like that, is that a question that they could ask you, Jen, and you could point them in the right direction, or?
Yeah, sure. I mean, we do that at DPNF. Obviously, we review people's handbooks and we do handbooks, and the Cal Chamber has a good resource for that as well. So I would caution you though, Cal Chamber has wonderful resources, but do not just take something off the shelf and implement it. I've seen a lot of handbooks that have come to us for review and they still have the fill in the blank, like written in the handbook. So, there is no like instantaneous handbook. It does take work, and it's one of those things that is so important, honestly. And we'll get to that in the risk management section that I'm going to talk about, because it really can be useful, not only in your day-to-day navigation of your employment issues with your employees, and it could be a resource for your employees, but it also, if you're so unfortunate as to get involved in litigation and sued, it's a resource that you could say, no, look, we told them this is our policy. Of course we didn't engage in this wrongful conduct that you say. This is what our policy is, and we told them what our policy is. So it's important to have those policies. It's important to follow them. But if you have a handbook that just says, fill in, appropriate person, it's going to be hard to say you actually followed it, since it doesn't look like you even read it yourself. So that's something to be concerned about. All right, so let's talk about COVID-19 in the workplace. So there are some updates and there's some carryovers. So the carryover is the notice provision. So AB 685 was put into place. It requires employers to provide written notice of COVID-19 exposure in the workplace to all employees within 1 business day of discovering the potential exposure. So if all of you guys are frontline human resources or managers or owners that are the ones that are dealing with COVID, this should be very familiar to you. You need to provide notice to your employees 1 day after you're notified that someone's been exposed, that there's been a COVID-19 exposure in your workplace. The requirement was set to expire January 1st, 2023, but it has been extended to January 1st, 2024 with some changes. If any of you are looking at this going, what do you mean we're supposed to provide notice to our employees of COVID exposure? We have a model notice, so you can just email me afterwards and I can send you a model notice that you can send out. It's good to just have it at the ready that you can send out to people. We have had employers get notices from OSHA, CalOSHA. CalOSHA is the one that's going to enforce this, and say, hey, we got notice that you're not, and it's usually an employee that's upset, and they may be upset about something else, but they go to CalOSHA and say, they didn't tell me that I was exposed to COVID. And hopefully this is going to get less and less. But people were legitimately upset when they would find out that they had been exposed to COVID and they were never informed, right? That probably has happened in almost all of your businesses because things happen, but people would get upset. They would go to CalOSHA. CalOSHA would send a letter to the employer saying, what are your policies for notifying employees? We've been notified, we've been told that you're not doing it. Up until recently, they've been pretty hands-off on that unless there's something egregious. They just want you to tell them what you've been doing, and then nothing's happened. I wouldn't guarantee that going forward that would be, there was a lot of leniency to employers to a certain extent, trying to deal with all of the stuff that was happening and changing so quickly. And frankly, CalOSHA is overwhelmed and understaffed. So they don't have time to follow up on everything, but I wouldn't rely on that. So I would definitely make sure that you're providing the exposure that, or the notices that you need to. So as of what's changed about the 685 notice, AB 685 notice, is that you can, instead of giving the notice to the employees directly, either by handing them a memo, texting or emailing, you can post it. So you're allowed to now post it, like say in your break room or something. But if you do post it, you have to leave it up for 15 days. And it has to, and you have to log the dates the notice was posted and keep the records for 3 years. The posting is of limited value. It's probably good, like if you're like in a large grocery store or something, where it's like, we've probably all been to the grocery store and you're like, oh, why is everyone wearing a mask? But like, that there's been an exposure there, that's sort of a telltale sign that there's been COVID exposures, and you see people working in stores that have masks now. Now that the masking requirement generally isn't enforced, but because there's so many, at least there used to be, so many exposures, having a notice posted was an easier way to do it than having to keep track of sending out notices all the time personally. But if you're a smaller employer, it's probably not. It just depends. People like to get the actual email, and it's nice not to have it posted up there on your board forever that there's been an exposure. It removes the requirement to report an outbreak of COVID-19 in the workplace to the local public health agency starting January 1st. So Napa County no longer wants to know if you have COVID, so don't call them. AB 1751 workers' compensation rules have been extended. So this one kind of falls through the cracks a lot, and I still get questions from clients wondering if they have to report to workers' compensation carrier that they've had an exposure, and the answer is yes. It's been extended for another year until January 1st, 2024. Employers have to continue to report all known COVID-19 cases in the workplace to their workers' compensation carrier within 3 business days. So this is, you have to notify the exposure to your employees within 1 business day. You have to notify your workers' compensation carrier within 3 business days of someone who has COVID in the workplace. There's a rebuttable presumption that employees who have COVID-related illnesses, that COVID illness is a workers' compensation injury, a workplace injury. I will tell you that I have not seen any workers' compensation carrier say that it is a workplace injury. No, I've had some clients have employees file claims, but almost always they just, as you can imagine, workers' compensation carriers are not in the business of paying money that they don't have to. So I haven't seen anyone pick one up. And it's really difficult to prove that it actually came from the workplace or that you have an extended illness that's related to it. I think we'll start seeing more long COVID cases and perhaps more COVID workers' compensation claims result of that. So we'll see. So what you need to take away from this is that you still need to report it to the workers' compensation carrier within 3 business days. I will also say that some of your workers' compensation adjusters don't know this. I've had a couple of people report that their insurance companies are like, why are you telling us this? We don't need to know this, but I would just keep sending it to them. Even if it goes into a black hole, you're doing your job. Outbreaks. So an outbreak under this statute means if within 14 calendar days of 14 calendar days of one of the following occurs at a specific place of employment. So if you have 100 or fewer employees at a specific place, if you have 4 employees test positive, you have an outbreak under workers' compensation code. If you have more than 100 employees at a specific place, it's 4% of your employee total. So a specific place of employment is ordered, or if it's ordered by a government or school official due to a risk of infection. Haven't seen too many of these happen now that the wave has gone through, but it is something to be aware of. If you start getting multiple cases, you should talk to your counsel about whether you have an outbreak and what you need to do. Oops.
Just a quick time check. We have about 5 to 10 minutes left. So
goodness. Okay. So COVID supplemental paid sick leave, this expired. You don't have to pay this anymore. December 31st, 2022. Probably you don't need to worry about this anymore. There was some carryover if someone was actually on a COVID paid sick leave as of December 31st, it did carry over to the year. So you did need to pay that. If you had anyone who had time off during 2022, and for whatever reason, they didn't tell you it was COVID related, or somehow you had a payroll error and you didn't attribute it to a COVID paid sick leave that they were entitled to, you still need to go back and correct that. So if they tell you, you to go back and correct it. The new regulations are here. There's a website here. You can click on that. They went into effect February 3rd, 2023. So the emergency rules are no longer, the ETS are no longer in place. They are now that they've called the COVID-19 prevention non-emergency regulations. This is sort of a rundown here. So exclusion pay no longer required. Exclusion, you do need to exclude people from the workplace according to CDPH guidance. So if someone has active COVID, they can't come to work, but you don't have to pay them. The CPP, IIPP, that's your COVID prevention plan. That's part of your IIPP. It used to have to be separate. This law allows you to make them together under one document. Testing, you still are required to make testing available at no cost during paid time following a close contact. So if you have an exposure at your workplace, your close contacts, you have to be able to provide testing for your close contacts, people that had testing that got close contact exposure. Face coverings, anyone who's had COVID or been exposed, had a close contact with COVID, they need to be wearing a mask in the workplace for 10 days. So the people that have COVID, obviously they can't come to work, but maybe they test negative at day 6 and they come back, they still have to wear a mask through day 10. And for those that are exposed as a close contact, they're supposed to test 3 to 5 days after they've been exposed. They're negative, they still are supposed to wear a mask for 10 days. The close contact definition has been changed. It's based on the size of the building that you are working in. So 400, I don't know why they did this. It's just like they just have to like throw curveballs at you, but 400,000 or fewer cubic feet per floor is if your building is that size, which is going to be most offices. If you have that size, a close contact is defined as sharing the same indoor airspace as a COVID-19 case for a cumulative of total 15 minutes or more over a 24-hour period. If you have a larger space than that, like say a huge grocery store or some of your production facilities, if you're a winery, they might fall under that 400 square foot larger. A close contact, or if you're outside, a close contact is defined as being within 6 feet of the COVID-19 case for a cumulative of 15 minutes. So one is you're sharing the airspace if you're in a smaller space. One is if you're closer than 6 feet. Offices, suites, rooms, waiting areas, break or eating rooms, bathrooms, or other spaces that are separated by floor to ceiling walls are considered distinct indoor spaces. So if you have that kind of setup, then that really limits the amount of close contact that you would have, unless you do a lot of interacting in the common spaces. Employers can use an online calculator. So, and they have it online that you can calculate the size of your workspace if you fall under that. Risk management, we've reached 11, so I will stop, but this is just giving you some tools in case you are worried about lawsuits, that we can, you can get that through the PDF, because I don't want to take up more of your time than we've already allotted.
Perfect. Thanks, Jen. We had a quick question from Fabiana, which I think is a good, interesting one, I think, for those of us that work in the hospitality. She asks, can you force a team member to stop wearing their face mask if there's no outbreak and they are just choosing to wear the face mask every day or sometimes?
No, in fact, that's a great question. The law specifically says that employees are allowed to wear face masks, so you cannot stop them from wearing it.
Okay, great. Any other questions for Jen before we wrap it up? This has been incredibly informative, also very scary. So thank you.
Yeah, yes, and if anyone wants a copy of the presentation for future use, just let me know and I can send it to you.
Yeah, absolutely. And we'll go ahead and post this video on our YouTube channel as well, so you have it. And the presentation, we'll send it out to everybody who is registered. So it'll be in your inbox very shortly. Well, thank you so much for taking the time to join us today. Jen, thank you so much for preparing such an excellent presentation. It was absolutely fantastic. And it sounds like Jen's definitely available to speak with you guys individually if you have any additional questions. So I'm going to go ahead and stop the recording now, and I appreciate all your time and being here, and hopefully